testimony. As I indicated earlier, the purpose of a closing argument is to summarize.
I'd like to welcome my guest for this hour. Here with me in studio, litigation trial attorney Rich Schoenstein. Rich, thank you for being here, especially in person, to be able to talk to you about this case as it's happening. And I must say, it looked like the judge was just about to out-talk the defendant, which can be hard to do. And you had commented a couple of things you really appreciated about this judge. Tell me what those are.
Well, first of all, is the way she's making a record in this case. She talks and talks and talks. That's all on the record for the appellate court. She is trying to protect this verdict when it comes in. She doesn't want any basis for someone on behalf of this defendant to overturn this verdict, and that is why she goes to great lengths. She cites case law. She gives her reasoning in detail. Judges don't do that in an ordinary trial.
You know, it just, sometimes the inconsistencies, we know that this defendant has relied on some of the, I don't know if beliefs is the right word, but sovereign citizens and some of what they espouse and what they adhere to. And yet he's saying, sovereign citizen, subject matter jurisdiction, you can't call me by that name. But then he wants to refer to the United States Constitution, First and Sixth Amendment. I could say whatever I want to this jury.
That's a great point. He wants the law when he thinks it's on his side, but not when it thinks it's against him. He's not going to get anywhere with this sovereign citizen nonsense. It's not, we don't let people drive their SUVs into a parade and say, oh, it's okay, they have their own jurisdiction. That's never going to happen. So it's a crazy theory. I don't know why he's so wedded to it, but you're also right. He's citing the law when it helps him.
Went over my First Amendment right.
Rich Schoenstein still with me. Thank goodness you're still with me, because this is something else to behold. It's unlike what most of us ever see in a courtroom, certainly one that's on national TV, Rich, but tell me about what are the constitutional rights of a criminal defendant at a trial?
Fundamentally, it is the right to a trial. This is his constitutional right. It's the right to have a lawyer, or if you eschew that, to represent yourself. It's the right to have a jury, which he has. It's the right to put on evidence, which he did. It's the right to make a closing statement, which he can. But it's not an unfettered right to say anything you want. The First Amendment does not trump the rules of evidence. It does not trump the rules of court. There have to be procedure. There has to be decorum. You know that better than anybody, right? So he can't just yell First Amendment and come into court and say anything he wants. It would destroy the court system as we know it.
And I love your distinction between these are your rights under the Constitution, but it doesn't mean you get to do all these other things and say whatever you want because of court rules, decorum, rules of evidence, all those things that as lawyers we learn and we know.
Riveting stuff. I thought they did a fantastic job. The state really honing in on what was important in this case, the intent and the victims. Rich, how did they do?
I totally agree with you. I think that closing argument was great. And I really do think they focused on what was important, because you could have gotten lost in 76 different counts. And she kind of bypassed the lesser important counts, and she went straight for the key issue, which is, was it intentional? And the bottom line for me is, you can't hit 70 people with a car unintentionally.
Right.
And there was no story ever in this case, but the closing was great on all those points.
All right, still with me, trial attorneys Erica Wilson and Rich Schoenstein. Rich, I'll start with you. One thing that was clear throughout his closing was that the state was going to give him wide latitude. And clearly, that was the right way to go if they were going to get this done.
I thought it was a brilliant move by the state. There was a big argument before the closing either began. He was going to say this, he was going to say that. The judge was threatening not to let him argue. And the state said, hey, judge, well, why don't we let him argue and see how it goes, and you can give a corrective instruction if you need. The state just wanted to get to the finish line, and they saw the fastest way between 2 points was to let him stand up and do his thing.
Yeah.
Totally the right call.
Brooks has proved the case for them. And again, it goes, Rich, to the old statement that if you are representing yourself, you have a fool for a client. I think this was a perfect example.
This was a perfect example because, you know, there's two things you need to win a case like this: evidence and a lawyer. And he didn't have either one. And the lack of a lawyer just made his evidence worse. Like, he could have taken the stand with a lawyer. It would have gone much better. He could have challenged some of the things he did and challenged the prosecution's evidence with a lawyer. It would have had a much better chance. I don't think at the end of the day he could have gotten acquitted in this case, no matter who he brought in, but he would have had a better chance.
So, you know, what are your thoughts on the fact that they decided to continue deliberations or start deliberations tonight?
Well, I don't think they're going to be slowed down by the evidence. They're only going to be slowed down by the sheer volume of the verdict forms, right? Because there are 76. So I'm back here at 3 o'clock tomorrow morning with Ashley Willcott, and I am sure there will be a verdict by then.
Yeah, no question.
Again, thank you for being here in studio with me. Immediate reaction that you had to the verdict.
I'm not surprised at all. I think everybody who watched this trial or any portion of it was anticipating this verdict. I applaud everybody in this trial who isn't Darrell Brooks. I applaud the judge for running a good trial. I applaud the prosecution for trying a good case. I applaud the jury for doing its job. And I applaud the victims and the witnesses, because every time you do a trial like this, you have to endure it all over again. And just to get through it is really something.
You're right, and it's traumatizing. Every time you have to talk about it, every time you have to testify, every time you have to meet with the victim advocate at the DA's office to prepare, re-traumatizes.
Your intent is known, Mr. Brooks. It doesn't have to be guessed. It's known.
All right, Rich, what is your assessment of the rebuttal? Did she shift her focus any, in your opinion?
So I love it. It was short and to the point. I love the bit with the Bible. If I have one quibble, I don't think she should have addressed him directly. You generally don't do that. I think that was a little bit of anger seeping through at the end of this case. And I don't begrudge her that at all. He's been a handful to deal with. But I think she could have made the same points without ever speaking to him in that way. It's a small quibble, but you asked me what I thought.
Yes, and that's the only time that she did do that, referencing he accused her of rehearsing her closing argument, and it felt like, well, she had to kind of throw it back at him because she does get the last word. What is your opinion about why the state in a criminal case, the plaintiff in a civil case gets the last word? Tell our viewers about what's the reasoning for that.
Oh, sure. It's because they have the burden of proof. And the party that has the burden of proof, and that is the state, and that's the plaintiff in a civil case, generally gets to go first and go last. So they get to put on their case. Now, some courts will do different things. Some courts will have the defense closing and then a full prosecution closing. This court, which I think is more common, has the prosecution go first, then the defense, and allows a rebuttal. And again, I really like that she kept her rebuttal short, because he didn't say anything in his closing that merited that much attention.
And that's the only point of a rebuttal, is to get up if you have 1 point, maybe 2, to make in response to the other side's closing argument. And the decorum of the courtroom, I cannot, Rich, say enough that, to me, the sanctity of it has to be preserved, as the judge did in this case. But let me ask you that same question. In all your years of experience as a trial attorney, have you had one that's been this difficult?
You want to know if I've ever had an opponent that had to be put in another room, then went into the other room and hid behind boxes?
I do, because
No,
viewers, all the viewers have said that, Rich, like, oh, has this ever happened to you? And that's a great point. Keep talking about that.
This guy was a petulant child. I mean, let's just call it what it was. He kept arguing with the judge. He kept making the same arguments over and over again. He kept making objections. He had no idea what he was doing. He would call something hearsay when the question wasn't even about what anybody said. He was waving his arms. I mean, someone showed the graphic I call the many looks of Darrell Brooks, where he's waving in one, he's shirtless in another, he's hiding behind boxes. I mean, that's not the behavior of a litigant. That's the behavior of a petulant child.
And I just love, as you're speaking, our team is showing him putting the boxes up that he then hid behind. Rich, you're right. And that's a perfect segue.
Swift justice here in a number of ways. Number one, anyone who's been in the justice system knows that getting a trial like this with all these victims to trial in under a year, it takes a Herculean effort. They got that done. And then swift in the sense that the jury only deliberated for 2 hours and 41 minutes.
And when you think about that 2 hours and 41 minutes, imagine this. At least an hour is taken up just filling out the verdict forms, because there were 76 of those.
Right.
They have to start by electing a foreperson. That probably took 15 minutes. Then they had to decide if they were going to stay overnight and finish. I know they looked at a couple pieces of evidence yesterday, but they were not held up in this trial. They unanimously concluded this guy was guilty. He was guilty of everything. I think they decided last night. They said, let's just sleep on it and make sure we all agree. Come back in the morning. I think they came back in this morning. They filled out those 76 forms, and it was done.
That's really what trial practice is all about. You're a trial litigator, got to be nimble, got to keep moving with what's going on, get a feel for what's happening in the courtroom, and act appropriately.
Your program is not long enough for me to tell you how highly I think of this prosecution effort. And not just the way they litigated the case, which was fantastic, but what you said. Michael, they took care of the victims. That's part of the prosecution's job, is to tend to the victims, to take care of them, to take care of the community. You saw this prosecutor's deep commitment to the community in her words and in her actions during this trial. Sensational job. The results speak for themselves.
Jones says the jury got it right. Never any doubt he's guilty. Thank you to the jury and prosecutors. Absolutely echo that sentiment. But Rich, let me ask you this. Do you see what happened here in the courtroom as a travesty or a mockery of justice? Or perhaps was this a shining example of what our justice system can be?
Oh, I think this is an example of the justice system prevailing. This is somebody who threw everything he could at the system, and at the end of the day, the system held. He tried to break it. He tried to break the courtroom. He couldn't do that. He tried to get a mistrial. He couldn't do that. He tried to get the jury to nullify the law. He couldn't do that. It all held together, and at the end of the day, got the conviction, deservedly so.
Yeah, and again, I've said this before, that, you know, our justice system is about how we treat the least or the worst. And I think the court treated this guy with respect, as much as he would allow, and gave him what I think at the end of the day was a fair trial based on the way things played out. All right, our next comment comes from Ron. Ron, his prayers came true. The jury did do what's right. Thank goodness. You know, I found it fascinating, his attempt at the jury nullification. On one level, you know, it was a little bit brilliant. You know, he's like, look, he was trying to tell them, I wasn't able to give you all the evidence in this case, so you have the power, jury, to go against the evidence that you're seeing and nullify their verdict. And he did get a chance to mention it, even though he was warned not to. So on some level, I give him some credit for that idea.
Well, I think it was the only shot he had, right? He couldn't get past any of the evidence, so the only thing he could say to the jury was ignore it. What was really brilliant, Michael, is the prosecution said before the closing, I mean, the judge was struggling with how to deal with this, and the prosecution said, nah, let him talk.
Right.
Let him go up, let him give his closing, because the prosecution understood that was the shortest point, the shortest line to a conviction. Kudos to them. That was brilliant strategy.
Yeah, kudos to them on every level. You said it too. You know, this prosecution did a fantastic job, and I credit them with getting this trial over, because I'm not sure what would happen if the judge didn't listen to what they had to say and follow their prompts. All right. Thank you so much, Rich Schoenstein, for being here. Real pleasure to have you on the show. Thanks for coming in and being in studio.
Great to be here. Great to be here.
All right, folks, you'll be sticking around. Coming up next.